So there I was, minding my own business, enjoying my respite from social media. Dressed very casually, hanging out with the fam, watching some football, when what should come across my phone but a piece of news that compels me to put out a video tonight. It turns out that the state of Maine has used the 14th Amendment to now become the second state in America to remove Donald Trump from the presidential ballot. Okay, let's get into this.
My name is Brian Trippett. I am your front porch conservative. Step on up to my electronic front porch and let's talk.
I had intended to take some time off from social media. Not completely, but just to pull back a little bit, recharge the batteries, and get ready for 2024. But events keep piling up on themselves and lead me to believe that I'm not going to get a bit of rest between now and the beginning of the year. Case in point, the most recent piece of news to come across my phone tonight, which by now most of you have probably already heard about. So let's get into this. From Politico.com, we read the following. Maine strips Trump from ballot, inflaming legal war over his candidacy. Activists and voters have filed numerous lawsuits around the country claiming the former president is barred from office under the Insurrection Clause. Article written by Zach Monterello. We read the following. Maine's top election official rejected former President Donald Trump from the state's ballot on Thursday, declaring him ineligible to serve as president because of his role in the January 6, 2021 attack on Congress. The ruling by Secretary of State Shenna Bellows, a Democrat, is certain to inflame a roaring national debate over whether the Republican presidential frontrunner should be allowed to hold power again. The decision makes Maine the second state in 2 weeks to disqualify Trump's candidacy due to the constitutional bar on office holders who supported or, quote, engaged in insurrection or rebellion. Last week, the Colorado Supreme Court barred Trump from the state's Republican primary ballot under a similar interpretation of the 14th Amendment, which, by the way, they have since allowed Trump back on the ballot in Colorado. Bellows' decision on Thursday increases the pressure on the U.S. Supreme Court to step in and ultimately decide Trump's fate, as the Colorado GOP petitioned the justices this week to do. Unlike the Colorado ruling, this one comes from an individual office holder affiliated with the Democratic Party, and Maine, unlike Colorado, has been a presidential battleground in recent years. Under an unusual state law, it casts one of its electoral college votes for Trump in both 2016 and 2020. Trump was quick to attack the decision, with an aide calling it, quote, partisan election interference, but his removal from the ballot in 2 states remains a stark illustration of his deep legal and political vulnerabilities. Bellows, who made the call in Maine because state law requires the secretary to adjudicate ballot challenges to candidates' eligibility, defended her decision in her determination. Quote, I am mindful that no Secretary of State has ever deprived a presidential candidate of ballot access based on Section 3 of the 14th Amendment, Bellows wrote. I am also mindful, however, that no presidential candidate has ever before engaged in insurrection. The decision will almost assuredly be appealed by Trump, but by becoming the second state to kick Trump off the ballot, it marks a major milestone for the effort by activists to bar Trump from seeking the Oval Office again, breaking out of the confines from an isolated incident in one state to the beginning of a pattern. Bellows, at times, offered forceful arguments around Trump's political conduct as a defense of her decision. Quote, Trump's occasional request that rioters be peaceful and support law enforcement do not immunize his actions, she wrote. Trump was aware of the tinder laid by his multi-month effort to delegitimize a Democratic election and then chose to light a match. She did, however, pause her own decision to strike Trump from the ballot in the state pending an appeal to the state judiciary. Quote, activists and voters have filed numerous lawsuits around the country claiming Trump is barred from office under the 14th Amendment's Insurrection Clause. That clause states that anyone who, quote, engaged in insurrection or rebellion after taking an oath of office to support the Constitution, is forbidden from holding any public office. Bellot's decision followed an hours-long hearing in the state earlier this month in which Trump's attorneys argued that she does not have the discretion to make a decision on Trump's eligibility. Let me get back to that. Eligibility and hadn't participated or aired in an insurrection. The challenge to Trump's eligibility propels Bellot into the spotlight in an unusual way. Many of her Secretary of State colleagues around the country have similarly been pressured to kick Trump off the ballot, but they've argued that the courts, not election officials, are the proper jurisdiction to make that call. But Maine state law effectively has Bellot serve in a quasi-judicial role for eligibility challenges that many of her colleagues do not. In a statement, Trump campaign spokesman Stephen Chung attacked Bellot as, quote, a former ACLU attorney, a virulent leftist, and a hyperpartisan Biden-supporting Democrat. He said the campaign, quote, will quickly file a legal objection in state court to prevent this atrocious decision in Maine from taking effect. A second state invoking the 14th Amendment to block Trump from the ballot makes it more likely that the nation's top court will step in to adjudicate the dispute. Colorado's justices pointedly noted that they were unlikely to have the final say. Okay, let's get into this. Never let it be said that the holidays are an uninteresting time of the year. Like I said at the top of this video, I thought that I'd be enjoying a complete and total respite from social media, thinking, well, what could possibly happen between Christmas and New Year's that I would need to cover in a video? Boy, was I wrong. But at any rate, let's stop and talk about this. I think I'm beginning to see the pattern that Democrats are starting to use when it comes to Trump. It's not so much that they want their decision as far as getting him off the ballot to stand, as much as they want one word ingrained in the minds of voters: insurrection, insurrection, insurrection. And then the phrase following that, Trump committed insurrection, Trump committed insurrection, Trump committed insurrection. There's just one problem with that. Trump did not commit insurrection on January 6th. There's a lot of things you can say about January 6th. There's a lot of things you can say about the people who participated in January 6th. You can say that there was a riot. Okay, I can legitimately see that one. You could say there was criminal trespass. Okay, maybe, but I have a hard time believing that, especially when there's video of Capitol Security opening the doors and letting people come in. You could say there was vandalism. Okay, we've got that, I understand. But an insurrection, that does not even begin to make sense. But the Democrats keep repeating this word, and nobody goes to the heart of the issue and asks the question, did Trump commit insurrection on January 6th? Well, I take that back. There is one person who has recently addressed this in a Substack article that he's written, and he's also a former guest of Chatting on the Porch. His name is Daniel R. Street. He's an attorney out of Louisiana, and I'd like to show you parts of his Substack article because they speak historically and legally to the true question at the heart of all this. Did Donald Trump commit insurrection on January 6th? If he did, then by all means, under Section 3 of the 14th Amendment, he can be removed. The problem is, at least by Street's interpretation, and for the record, I can't disagree with him, that's not what happened. I take you to the Substack article entitled, Trump Disqualified from the Ballot in Colorado, a look at the Colorado Supreme Court's radical lawfare decision to exclude President Trump from the presidential ballot. Now, this was written in the context of the Colorado decision. This was before Maine ever came out with what they did today. So let's take a look at what he's got to say here. And I want to take you into the article, and I'll show you what I am talking about in particular. And I think you're going to find this to be particularly relevant. Here we are. Daniel Street writes, furthermore, the term insurrection has been in use in federal law for over 200 years through the Militia Act of 1795 and the Insurrection Act of 1807. These acts live on today in modified form in federal law as 10 U.S.C. 251. This law allows the president to call the militia of any state into service when, quote, rebellion makes it impractical to enforce the laws of the United States in any state by the ordinary course of judicial proceedings. This law specifically requires the President to order the insurgents to disperse and retire peaceably within a limited time, whenever the President considers it, quote, necessary to use the militia or armed forces under this chapter, 10 U.S.C. 254. Readers will note this provision of law remains nearly verbatim from the original Militia Act of 1795. Historically, the President's proclamation under the Insurrection Act and thereafter sending in federal troops defined insurrection. Let me read that again, ladies and gentlemen. Historically, the President's proclamation under the Insurrection Act and thereafter sending in federal troops defined an insurrection. This is covered at length by various commentators on the issue. See Disloyalty and Disqualification, Reconstructing Section 3 of the 14th Amendment, William and Mary Bill of Rights Journal, Volume 1, Issue Number 5. The commentators note, insurrection and rebellion have high bars that, in light of the proclamation requirement, should be obvious enough, and Section 3 should be easy to apply to those engaged in them. Though the President has sent federal troops to quell insurrections without proclamation and without apparent statutory basis, it is hard to believe that a court or Congress would allow for a deprivation of somebody's right to hold public office according only to the President's subjective and secretive assertion. A basis in law which requires a proclamation should then underlie a Section 3 challenge on the basis of insurrection or rebellion. The test then is basically this. If somebody voluntarily takes part in a scheme that causes such domestic unrest that the President issues a proclamation pursuant to the Insurrection Act and calls the National Guard or other military forces to suppress that scheme, then they have engaged in insurrection or rebellion and could be disqualified by Section 3. The problem with that is none of what is being described by these commentators and by Daniel Street happened on January 6th. None of it. Consequently, you can't accuse Trump of engaging in insurrection. If a president does not call out troops to put down rebellion in a state, or in this case, District of Columbia, and give the individuals rebelling sufficient time to disperse, then it's not an insurrection. And I am dying for this to get to the United States Supreme Court to get to just that question. But we read a little bit further into this article. There's one more part I want to get to. And it is this. Daniel Street continues, as I previously covered in yet another previous Substack post, President Trump did not incite any riots in his January 6th speech. He literally called for his supporters to, quote, peacefully and patriotically make their voices heard, and stated that he and his supporters were going down to the Capitol to, quote, cheer on our brave senators and congressmen and women. Like the fake news media and lawless January 6th committee and House Democrats under former Speaker Nancy Pelosi, the Colorado Supreme Court makes clever use of ellipses and selectively quotes the handful of passages in the speech where President Trump said, we fight, and we fight like hell, to reach their grossly erroneous conclusion that he engaged in insurrection. Grotesque. President Trump's speeches and public statements on January 6th and prior to that about the rigged 2020 election are political speech protected by the First Amendment to the United States Constitution. As I've cited in the previous Substack post, there are statutes in the District of Columbia covering inciting riot. But President Trump was not charged under those statutes because his speech on January 6th and other public statements did not violate the law. And that's a very important point, ladies and gentlemen. If you're going to say he engaged in insurrection, then how come he's not at a minimum being charged with inciting a riot? They didn't even charge him with that. So if they're not even going to charge him with that, then how can you possibly charge him with insurrection? If he doesn't even cause a riot to come into being, then how can you say he even caused an insurrection to come into being? We continue. As I previously noted, one of the former Washington, D.C. prosecutors who enforced these laws so often, he was dubbed the protester prosecutor, A lawyer named Jeffrey Scott Shapiro wrote an article for the Wall Street Journal published January 10, 2021, entitled, "No, Trump isn't guilty of incitement. Inflaming emotions isn't a crime. The president didn't mention violence, much less provoke it." So, ladies and gentlemen, now Maine has become the second state to kick Trump off the ballot. And I do agree with the Politico article. This is going to put even more pressure on the Supreme Court to handle this, and frankly, they should. This has got to stop. Whether it's Colorado, whether it's Maine, whether it's Texas or Florida or Arizona, who are now considering the idea of removing Joe Biden from the ballot on what they feel are valid constitutional grounds, this has got to be settled. The Supreme Court has to answer two very important questions. And the first one begets the second. Number one, did Donald Trump engage in insurrection on January 6th? And if the answer to that question is no, then that begs the next question. Can you use Section 3 of the 14th Amendment to remove him from the ballot? And this is going to be one of the most fascinating pieces of legal judgment the Supreme Court has handed down, I could argue, since Gore v. Bush in 2000. So we'll see what happens. But that's what I've got to say about it, albeit from my shortened vacation. But in the meanwhile, do me some favors as always. Number one, if you're not a subscriber to my channel, please do so. Number two, please hit the bell for notifications. I want to make sure you're always aware when new material is coming out. Number three, please leave a comment below. I would love to know what you think about all this. Number four, please share the video around. And finally, give me a thumbs up. My name is Brian Trippett. I am your Front Porch Conservative, and I will see you next time.